Okay, thank you, David. Thank you so much. And thank you, Professor Mario Viola and Professor Ian Oppermann to accept our invitation to this closing session of Legislature for Democracy 2021. This panel have a special topic because this was one topic that got many legislative houses around the world while moving to remote action. First of all, I would like to present our panelists for today, our keynoters. So Professor Dr. Ian Oppermann is the NSW government's chief data scientist working within the Department of Customer Service. He's also an industry professor at the University of Technology Sydney, UTS. From 2015 to 2019, Ian was also the CEO of the NSW Data Analytics Center, DAC. Ian is considered a thought leader in the area of the digital economy and is a regular speaker of big data, broadband-enabled service, and the impact of technology on society. Ian has also an MBA from the University of London and Doctor of Philosophy in Mobile Telecommunications from Sydney University. Ian is a fellow of the Institute of Engineers, Australia, a fellow of the IEEE, a fellow of the Australian Academy of Technological Science and Engineering. He's a fellow and the president of the Australian Computer Society and a graduate member of the Australian Institute of Company Directors. Professor Dr. Mario Viola is a compliance officer of the Data Privacy Office of the World Bank. He also holds a PhD in law from the European University Institute, and beside of all is a very good friend of me. Thank you so much for accepting this invitation, Professor Mario and Professor Ian. So first of all, I'd like to also present our panel for today that's entitled Terms of Use and Privacy Policy in Legislative House. So many legislative houses around the world have moved to remote action due to the COVID-19 pandemic. On the one hand, it brought more possibilities for representatives to perform their functions and brought their constituents closer to their representatives. On the other hand, the sudden movement due to the health emergency brought legal and administrative risks for the regulation of the legislative houses. Dependence on third-party technological tools mean that legislative houses were subjected to terms of use that were not necessarily in accordance with local and specific legislations. This panel will discuss the dilemma experienced by many legislative houses on this topic. So for the dynamics for this talk, I would like to make it very dynamic, and you were free to talk whenever you want. So we were going to avoid long opening remarks, and I will start with you with a broad question that you can introduce the topic from your academic perspective. So interaction between speakers during the webinar is very encouraged. So we have noted conflicts between what terms and conditions of the per platform say and what we get in the real world. We have experienced situations like Parliament videos removed due to alleged terms of use violations. Taking into account your expertise, would you encourage parliaments to adopt third-party solutions accepting their own conditions, or would you encourage them to develop their own solutions in this regard? So I'd like to start with Professor Mario Viola.
Hi everyone. Good evening. Oh, good afternoon to everyone. So I'm I'm in the evening, but it's a good afternoon to everyone. So thank you, Marco, for the invitation. As you said, like the highest title that I have is being a friend. So, well, thank you for this opportunity. Today, as I already told to Marco, I'll be speaking on my personal capacity, so not on behalf of the bank. So the views here are my views and not those of the Data Privacy Office of the World Bank. Well, I think it's a very interesting question, and my, let's say, my initial, let's say, reaction would be, well, it depends on the case. I think it depends on what parliaments they want to deliver through the use of platforms. So using social media to reach different, let's say, audience, of course, as you said, I think there's some risks. So content can be mediated, moderated, and different countries around the world are pushing platforms to somehow monitor and avoid like content that could spread, like, for example, fake news or content that could somehow promote hate speech and other, let's say, illegal content. So it depends. I think, well, COVID made like institutions around the world, not only parliaments, but governments in general, to trying to find different ways to reach, let's say, the audience and even to work. So you see parliaments now voting different issues through web platforms, and of course it has some risks in terms of privacy, but not only, as you said. So talking from a more privacy perspective, I think as we have like a different choice of a varied choice of platforms, I think the first step would be to assess the risk in terms of the data that we process. I think parliaments and organizations around the globe, they should assess the risks of using one or other platform. The terms of use, of course, they are the rules of the game. So I think they need to assess that. And of course, if it's official content that you have to publish, you should go more maybe for your own platform, like for the traditional, for example, website, and having like laws. Imagine if you are wanting to post like legislation in social media, maybe that legislation can be by mistake or because it violates some specific terms of use, not be published there, be deleted from the platform. So I think depending on the type of content, on the type of message, the audience that you are, let's say, targeting, I think parliaments have a wide variety of options, and they could look for different things. I would say, like for official content, I would try to, let's say, of course, you can also post on social media, but you need to have like your presence online in your own, let's say, website or your own platform. Well, I think that's my initial reaction. I don't know if Professor Jan has any thoughts on that.
That what you said, Mario, is very interesting. Maybe we should balance in some form the official content for not rely entirely in platforms. I'm saying that especially because we had cases that Bússola Tech is following the Parliament's work around the world, and there were cases, and when Parliament live streaming a session from the Parliament, and for somehow or a word speech by a congressman or congresswoman violate the terms of use of the platform, and they shut down that content. Maybe a good point is not rely entirely in the platform, but maybe have also a backup of that content to further consultation. So, Professor Jan, I would like you to answer this initial question, and thank you once again for accepting our invitation. And thank you so much to get up so early in Australia. It's at 5 o'clock in the morning. So the first initial question, Professor Jan, was, would you encourage parliaments to adopt third-party solutions accepting their own conditions, or would you encourage them to develop their own solutions?
So thanks very much, Marco, for the question. And yes, it's lovely and early here in sunny Sydney. One of the things that we're working on at the moment is an artificial intelligence assurance framework, and it may seem like a bit of a step into the wilderness to answer it in those terms. But the assurance framework has built into it not only a consideration of all the different possible benefits, but the potential harms from use of artificial intelligence. And one of the things we're trying to do is connect the people who are responsible for use to the people who are responsible for the procurement of these solutions, because typically people develop their own solutions initially because there's nothing in the market. They have a particular need, a particular objective they're trying to achieve, and there's nothing in the market. So what we're trying to do is connect the benefits and the harms and the risks back to the people who are looking to procure solutions. But ultimately, there's a strong tendency for people to develop their own, if you like, generation 1 solutions, but over time the market starts to catch up, and then therefore generation 2, generation 3 solutions tend to be developed by the market. But there is in general, I think parliaments and governments ultimately should not be in a position of developing data or software or even AI solutions. They may well be in the position to explore, experiment, try, test, and learn with their first generation solutions, but ultimately I think the market should catch up. But the challenge always is connecting those who are looking to build or purchase solutions to those who actually have the responsibility for operation of solutions and for delivery of the outcome associated with those solutions.
Thank you, Professor Jan. So in the topic of privacy, and specifically about general data protection, I would like to ask Professor Mario, that is an expert on this topic. So during the pandemic, Professor Mario, many parliaments moved very fast to, as we just said, to remote action, and many of them trusted on third-party platform to keep their work running during the pandemic. So data protection and privacy were the least concerned during the health emergency. And we also perceived many authoritarian movements about that, especially because we didn't have strong boundaries established on that topic, and that was an issue. But safety for representatives, to deliberate and cast their votes were also a bigger concern than the data protection in that topic. So was prioritized from data protection. So if you were a parliament data officer while remote deliberation tools redesigning, what would you suggest for remote deliberation, electronic voting, and other useful tools for the legislative digital transformation? I mean, the pandemic is ending now, I hope. So many parliaments will start to redesign that tools that they are using for remote deliberation. I think remote deliberation came to be a new trend for the parliament. So for the parliaments that we will start redesigning these tools, what would you suggest as a data officer for parliaments?
Yeah, well, I think it's in that case it's much more from an information security perspective than from the data privacy one. So of course I do see some issues in terms of data privacy and personal information, but to the extent that like members of the parliament are publicly, let's say, figures, they public, let's say, individuals with some less, let's say, layers of protection in terms of privacy, because of course they do have it to, let's say, to be oversaw and by the general public. But I think like issues like encryption, so tools that should be, any tool that would consider voting, and especially if the voting is not like, for example, public. But of course, information security, it's important to avoid that someone changes the voting score, and so encryption, cryptography, this sort of information. I think Professor Jan is a much more experienced expert in that field, but I think it's much more in terms of information security than privacy or data protection, because, well, the individuals or the data subjects, as we say in the language of data privacy, they are not those that deserve a higher level of protection in that sense. And also because this type of personal data that circulates within a voting experience are not that, let's say, it's not the same as someone voting for a candidate or voting for an individual going for elections, because then it shows the political affiliation and so on, which would be some sort of sensitive data. But in that case, politicians, they are already associated to a specific political party, which is their affiliations known by the public. So I think it's much more in terms of ensuring that the tools that are used ensure the level of security that the voting system deserves. Well, I can pass to Professor Jan, because he's the computer scientist and has probably a better insight on this than me.
Would you like to comment that, Professor Jan?
Yeah, thanks very much. So in general, one of the things that we spend a lot of time thinking about is data sharing and use, and for voting or for other purposes. Not all data is the same. Some data is very personal, some data is very sensitive, some is personal and sensitive, some is not sensitive and personal, and so on. And so treating data differently is a really important way of developing the governance frameworks for how you go about protecting and considering appropriate use of data. It's also important to think about data from the perspective of its entire life cycle, from the point of creation to transmission, storage, use, analysis, reuse. And these lenses of what we're dealing with and the data life cycle start to develop ways of thinking about appropriateness of use, and also about how you should protect data. So in general, I think the argument is that we can build different frameworks for thinking about data. And if you are working in the sensitive and personal space with data, then you have to be, of course, very, very careful about the governance and protection of the frameworks you put in place, and also think about the appropriateness of use. And so to the specific question, I think there's, I think many organizations, many parts of government typically will assume that data is either nuclear material, it's very sensitive and very personal, and treat it that way, or put it out as open data. And there's not a lot of shades of grey between those two worlds. And so with my personal crusade is to try and, my personal mission is to try and help people think differently about different data sets, treat them in an appropriate way. And I think with regard to voting and with regard to engagement with the public, some care is needed, but also I think the ability to introduce reproducible patterns of understanding of how to deal with different sorts of data is important. Voting data, I think, is a really, really tricky one, because it's very personal, it's very sensitive, and we should treat it as if it's in that top right-hand corner. But there are tools and templates and patterns of appropriate behaviour we can develop to handle that sort of data.
So following that, this point that when we talk about public data, they are so important to maintain institutions, that they tell a history of institutions. And as Professor Mario was saying to us in the beginning, that the importance that to have a strong archive of official data. So, but when we talk about public data and how some parliaments are choosing some third-party tools and also social media tools and video conference tools. Once these tools also holds this public data, we have also an issue about political sovereignty. How we can guarantee this property of those public data for the public? And what do you think about this question, Professor Jan? So how risky is for the nations to entrust public data to third-party private companies?
So it's a very, very big deal. And in Australia, we've just recently taken the step to say that data centres are an important national asset, and that's slightly overstating the case. But it says that you cannot sell your data centre to just anybody. You no longer have complete freedom of commercial operation simply because of the importance of the data asset. So Australia is recognising data as an asset, and it's recognising that it has real value, and it has real value to the nation. So there are now some more increasing restrictions on what you can do with your data centre if you're a commercial entity. Data as an asset is actually really an important and big topic, but the New South Wales government recently released its data strategy, which said that we will treat data as an asset. The implications are, and those implications include, we have to value data, we have to think about impairment of the value of data, we have to think about the costs associated with maintaining the asset of data. And I think that's an imperfect but important step forward to start to realise just how important data actually is, again, during its entire life cycle. And the statement about life cycle is also important because we have to think about data from the point of creation all the way through to the archiving and potentially subsequent deletion or removal of data. And if you don't think about the entire life cycle, then you potentially miss both the value and the risk associated with data. So I think slowly but surely we're starting to understand that data really is an important, fundamental, a little mercurial, but fundamental capital asset that we have to draw on and we have to use. And until we build an accounting standard, until we build some of the most important frameworks around data, we will still be a little blunt with how we understand the value of it and how we protect data. But I think we are starting to take the right sort of steps and realising it's a very important component to how we operate as government and how we operate as society.
Thank you. Professor Mario, would you like to comment that? And I would add something that as you, as a general data protection expert, when we talk about general data protection, we are focused in the individuals. But can we think about a GDPR for states or institutions in this sense?
I think thank you for giving me the floor. I think it's much more, we're not talking about privacy for the states, but it's much more for, let's say, the balance between individual data protection, privacy, and an open.
Let me clarify my question. Sorry, Mario, Professor Mario. Let me clarify better. I got that thought because when we talk about the GDPR, we have a right established that the user is the owner of their own data. So that's in this sense I was meaning.
Yeah, no, but I think it's different, because when we're talking about parliaments and governments, it's much more that the information is for the public, by default. Of course, you have limitations and restrictions in terms of levels of confidentiality, where if it poses risks to state defense, to state security and other, let's say, more broad issues related to the protection of the state as such, but the information like documents should be by nature public, produced by the state. I think that's the logic behind the use of open data and open access to knowledge. So I think it's much more to find that balance. So and that's, I think, the main issue that states which have a data protection framework and also have, let's say, an access to public documents framework, somehow struggle to find the balance. So they need to see how to balance the needs, let's say, to give access to information, this right to give access to information, because it's much more than that, or the loss of access to public documents and information, and to protect the individual. So to what extent the information of someone that is in the specific document should be kept, let's say, private and confidential. I think that's the main issue, and the states have been, let's say, somehow finding their balance, and you have the European Union, now the European Union member states, with directives and rules that somehow establish this specific balance. In Brazil, we are nationals of Brazil. So in Brazil, you have like the law on access to public information, and you have the recent, let's say, data privacy, data protection framework. And there again, you have like rules that say, that somehow establish that limit. So to what extent we can prevent access to public documents, information based on data protection. I think data protection shouldn't be an excuse like for a blank confidentiality or restriction of public documents. It should be on a case-by-case basis, and it has to be duly justified. So you don't give access to information if it really touches like the private sphere of individuals. I think that's the balance that we have to look for.